Okay, so I'm going to go ahead and we'll get the meeting called to order. It looks like there's a quorum here. Like to go ahead and,
Chair, if we could, just for record-keeping purposes, do a roll call at the beginning of each meeting so that we have a record on the meeting. Who was here?
do you want me to run a list, just run through the list, or do you want me to?
Yeah, you can just.
All right, we'll start with the roll call. Paul Charnetsky is here.
Ann Allen, present. Susan Fix, present.
Chuck Emmert, present.
Sonny Culberth, present.
Ann Claire, present.
Gay Romack, present.
Robert Zabadick, present.
Michael Faith, present.
Ken Jones, present.
Okay, then Will Felice is on Zoom, and we have heard both from Martin and Frazier that they won't be here today, but we do have and Lisa Brainerd is not here today. Is that right?
Still come in.
Okay. Great. We'll go ahead and do the Pledge of Allegiance.
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Yeah. New residents.
So the city manager is here then. So the first line of business, we'll go ahead and have to approve the minutes. There is a packet of the minutes. We have the roll call from the previous minutes, and then we also have the minutes from the last two meetings that have been recorded and are held by the city. Is there a motion to approve the minutes?
So moved. Chuck Emmert.
Is there a second?
I'll second.
Before you vote, I think the minutes for Tuesday may have an error in Thursday instead of Tuesday. That's a Scrivener's thing, but.
Okay, we'll get that corrected. And then is there any other discussion? All those in favor of approval of the minutes?
Aye.
Opposed? So we're going to continue where we've been in the discussion of the draft charter. The last time meeting we left, we were at Article 10, elections. We started with the ethics and then went back and did the other finance and the other two in that order. So we actually started with the ethics last time, but we'll go ahead and start with Article 10 on the elections. Our goal here is to hopefully get through the next 7 articles here tonight. The city, as well as the legal, has been editing along. We've had discussions and we've been taking some individual notes. We're going to have a drafted hopefully by Monday with the edited version at that time. And then at next Tuesday's meeting, we'll have the opportunity to go through that entirety and opportunity to discuss those areas that we were still in discussion. And then if we have time tonight, hopefully we can, and then there's any additional items that somebody would like to talk about that has additions to the charter itself, we can go ahead and talk about that because that is on the agenda. Okay. So we'll go ahead and start with Article 10, Section 1. Page 22. Sonny, did you have a question?
I just wondered if she could make it a little larger.
So these appear to just be standard kind of cut out from a previous I don't know that there's anything else on there. Do they need to be cleaned up at all from a legal standpoint?
Chair, these provisions in this draft that was provided to you was just essentially taking provisions from other charters throughout the state to try to give you guys a working document. So you can take whatever's in there if you want, or you can, you know, get rid of it and put your own language, put your own positions in there. If you have any discussions that's different from what those are, what we tried to do is look at the other charters and find language that was common between the charters and give that to you so that you just have a basic framework to go off of. But from our perspective, you know, this is your process. You could take this entire document and throw it out and start anew, which I know you don't want to do.
We don't want to do
Wanna
that.
take
We've been
that,
through a
no.
lot already. So, and as far as the elections, does this have anything to do in terms of the dates that, do we still have required to?
Yeah, what this would allow, and basically what a charter allows a charter city to do is to maintain your local elections on your own time period, as opposed to going with the state's mandated. You know, they forced all the municipalities to go to the federal election cycle. A lot of charter cities didn't want to do that because they felt that it inundated that election ballot with way too much information, and you would get voter fatigue because of those issues. You'd have super long ballots. So they wanted a process to where they could keep their elections local and keep them on their own cycle. The flip side to that is it costs a little more to do that. Not much. And Terry.
Kenny?
Thank you, Mr. Chairman. So I kind of skipping around because the dates are in section 6, but if we want to address dates, I had asked Terry this before at the end of the last meeting, and I thought instead of putting dates in here, what if we said the city council by ordinance shall establish the dates for elections locally, so that if they change their mind later and want to have it on a different date, they can do that without a charter election. So the city of Tucson, who went through the courts to try to solidify their local election dates, and there was an objection raised by the legislature, one, because they were a charter city. So I think if we just put in here that the city council can establish dates differing from state or county dates by ordinance, then that gives them the flexibility to do that. I'm really nervous about putting an actual date in the charter.
I would agree.
So that's in section 6, right? So in section 2, a similar comment. At the second line up in section 2 from the bottom, it says the council has the power to make additional provisions to be consistent with what I've said before. I think I know these all come from different sources, from different charters and things. To be consistent with what we've said, I think it should say power to make by ordinance additional provisions. So we're stating in here how they can make those changes. I just think that's consistent with what we said last meeting. And then in section 3, this is talking about the qualifications of electors. And I thought that was covered in Article 2, Section 4. That's what my notes say. Let me look real quick. Article 2, Section 4. Does it cover that? Or is it only?
That may be the
Oh,
qualification.
that's only the qualifications of the
Yes,
elected.
that's for the,
Not for the position.
Okay.
As opposed to.
Okay. I might have been tired when I made that note. Section 5, it says election shall be indicative of it's talking about nonpartisan. Shouldn't we be talking about no political party affiliation there? Nothing on the ballot in any election shall be indicative of the candidacy. Is candidacy synonymous with party affiliation? I don't think so. I don't know what candidacy means in this context.
If you want to clarify that and have additional language.
Okay, well, the only thing that makes sense to me,
No
Political
party-
party affiliation makes a lot more sense than candidacy to me. I don't know what that means in that context. Okay, I covered section 6, that timing. And then I think if we're going to talk about how votes are cast and counted here, a lot of folks, I think in their charters, I don't know about in Arizona, but other places have the rules for settling a tie vote. They say you cut cards or you flip a coin or you do something. And if it's not in the charter, or at least a reference to the settlement of a tie vote shall be determined. I don't want sitting council members to make that decision on that date when they might be the ones that are involved in the tie. So if we just said here, what do you do in the case of a tie? Then we resolve that. That's all I had in that whole article, Mayor, Mr. Chairman.
So that what would that mean then if we had that addition that the council would decide on the dates, we wouldn't even need to have a section on there about the dates?
Right.
That we would need that section 6.
Well, whatever Terry comes up with is fine, just to say that the council can establish those dates, whatever dates they can establish. Like you said, there are state statutes associated with statewide and federal elections when you have to hold those elections, I think. But I think you have some leeway in others, local elections that, you know, that you can control the date. Is that correct?
Yeah, and that's one of the main benefits for a charter city is to be able to have that local control because it's an issue of local concern, not an issue of statewide concern with regard to city council elections.
Yeah. I would love to give the council that leeway to be able to make those changes in ordinance later.
So then we could add that. And then I do think the comment, no political party affiliation could be also put in that nonpartisan election section 5 or reworded to have that in there.
I do have a question as to, is there any reasoning behind why May was suggested?
Yeah, because if you're not going to do it on a August, November cycle, the only other cycle is a March, May cycle.
For timing reasons?
That's how the county does the elections. So every year elections are still held. It's just they're considered special elections as opposed to regular elections. So for example, in 2023, we had elections in March, May, August, and November. And I think the purpose is that typically most municipalities, when they're doing their off-cycle municipal elections, they're doing it in the March, May time period as opposed to the August, November time period, so as not to confuse voters. So everybody knows that if it's a May election, that's a council election as opposed to, was this an odd numbered November election or an even numbered November election?
So even if we had a higher level council can enact by ordinance, there it would either be March, May, or
August,
November. Okay.
But if you don't put it in the charter,
But that would still give the council the flexibility to decide on which one.
Right.
And then if they had to have a special election, they could have all 4 elections. Yeah. And then currently there's not anything in there about what to do over a tie. Is that right? A tie vote. And do we need to have?
We can add some language.
Well, the only thing on that, I would like to see kind of what the standard is. I mean, flipping a coin or, you know. Jesus.
I've seen
Oh, so-
cutting cards. I've seen them cut cards.
Oh, it says, well, that would be fine. Then we could put in there just as some sort of a chance, game of chance or something.
I like to see who's a better shot, you know, just.
No.
I knew.
Yeah.
Go back to the tombstone days.
So back to Article 10. In Section 1, A and B, they look pretty good too. We talked a little bit about 3, and then Kenny's points regarding the timing and then party affiliation. Anything 1 through 6 that anybody has any other concerns about?
Mr. Chairman, I just have one question.
Chuck?
In the area under A, general elections, is there a way to simplify that language so that when it's a little more understandable? I'm thinking of voters to go approve this charter. That is just a lot of words there that it's just difficult to understand. And I don't know how to simplify it. I'm just asking if that's something that we could be helped with simplifying that. And in section A, under general elections.
Where it talks about if any primary election, there's any office, which is no candidate is elected, et cetera, et cetera. We can take a look at trying to parse that down. The issue being you have to have it sufficiently detailed enough to try to address, for example, the instance of a tie, try to address issues that may never come up, but could come up. What if you have a tie in the primary? How is that addressed? Different things like that. I'll take a look, and we can compare that to the language that's in the statute. But my preference is try to avoid as much legalese as possible, make it as simple for the ordinary individual to read and understand. And also with what Member Jones has said, try to keep it as basic as possible, because if you put in dates or references to statutes, things that could change in the future, then you have to go through this long process of doing a charter amendment, which requires a vote. And I've seen a number of instances where, the other charter cities that I've worked for example, Yuma has had a heck of a time trying to get the charter amended to address the spending authority for the city administrator, because the number that's in the charter is almost 30 years old and just not applicable. Kind of have to have more than $5,000 spending authority for your city administrator in this time period as opposed to 30 years ago. But getting things like that changed can be difficult because people just see it as, oh, you're just trying to spend more money. And it makes it difficult for those types of things to change. So you try to word it in a way to where you still have that control, but you remember you have your charter, and then you also have your city code. And as much as you can keep in the city code with the specifics, details, references to statutes and things like that, because the city code can be amended and updated and corrected in a much easier fashion than doing an amendment to the charter.
It kind of goes along with what we talked about on some of the earlier topics, keeping it more general so that we weren't going to lock things in.
Right, yeah, and just keep it understandable. But I agree with, like what Ken said, keep as much local control as possible.
Lisa?
Sorry, Article 10, Section 1, second paragraph of Section A appears to be the exact same verbiage that follows in Section 7. And I'm just wondering, can we delete one or the other? Section 7, paragraph B. Or I'm sorry, paragraph A.
One's talking primary and then the other one is talking general.
Except up in Section 1, it talks about primary first, and then the second paragraph is section.
Right.
Section paragraph is general election. So it seems to be addressing both the primary and the general in that section. Am I reading that wrong?
It says if at the primary election though, that didn't occur. So this is during the second or during the general election, something.
I think this addresses if there's a tie
Okay.
in the primary, those are the nominations to go to the general.
If there's a tie. Whereas the first sort of, Board Member Brenner Watson, I think it could make sense to consolidate these. Your point is that they're on the same topic. I think the language is, so A is talking about when someone wins the primary and gets a majority, we can skip the general. Whereas 7 is saying if no one gets a majority, we have to have it. But you're right, they're both rules for primary election.
Thank you.
And although you may not have an issue here in Litchfield Park, there have been instances where haven't been any candidates that submitted in time for a primary. And then there were write-ins for the general. Another example of having a charter provision that is very specific with regard to timeframes that makes it difficult for council members is I represent the city of Bisbee, and Bisbee has a charter provision where if a council member resigns or is no longer leaves office, the mayor and council have to appoint a replacement no earlier than 15 days after the date of resignation and no longer than 30 days. And that's a charter requirement. We had an instance where we didn't get any candidate submissions to fill that seat for 2 months. So we were technically in violation of our own charter, but you couldn't force somebody to put their name in to fill that seat. So it was just an example of how a very specific charter provision can be difficult to address in real life circumstances.
Well, this seems general enough that it gives us that leeway that we don't have to make that change.
Could you talk about what you were considering for section 11? It's makes me a little nervous. We're talking about election signage, and I think we have a sign code in the city that addresses all signage. So are you considering putting something specific here that only relates to election signage?
That code also addresses elections.
It does.
It does.
But in here, we're talking about limitations on election signage, and I'm wondering why we would add something here that is in addition to the current sign code.
It's just something that other municipalities have, was put in there again just as a placeholder. If that's something you guys
It
want to
just says to
consider.
be added, whether we want to have that
Yeah,
in there.
If
Does
that's
that,
something you want to consider, great. If it's something you don't want to, we take it out.
So since the Supreme Court ruling, which was terrible, that said you can basically put any sign anywhere in the city, you don't even have to read the sign, whatever it says is fine, and no sign can be held any differently than any other sign. So if you allow something for election signs, then you have to allow the windshield repair crack repair sign, and you have to allow every other sign that anybody wants to put. So I don't know what would go in here specific to elections, other than you can't put signs up more than X number of days before the election. That's the only thing I've seen that makes any sense in any charter or sign code, not charter, sign code.
There are limitations you can, since and that was a Gilbert case. It actually came from Arizona that the
Right, it was
Supreme
awful.
Court
Awful.
addressed the sign issues, and that was an issue where they were having directional signs for a church that they weren't allowing, but they were allowing other signs and things like that. So there are limitations you can do. They just have to be uniformly imposed. There are specific exceptions in state statute when it comes to election signs. But there are some limitations that you guys could have. I mean, a lot of times you can address those through code, but you want to make sure that signs are not put up in for example, the sight triangle at an intersection. There's a specific sight triangle that you don't want anything in there, because that is where you see the roads from. We call it a sight triangle. There's an area in engineering that keeps you from being able to put stuff there that would block a view.
But just to that point, if you're going to talk about that for election signs, it will apply to all signs. The Gilbert Church is exactly the right example. If the Church of Litchfield Park wants to put a sign in that same area, you either that's allowed or it's not allowed. You can't allow it for elections and not for somebody else.
Well, there are certain things you can allow for elections because election signs are treated a little different. You would treat, for example, you would have to treat the church signs, commercial signs, other signs uniformly. I think there are some exceptions when it comes to election signs, but we could look into that if that's something that the board wants to consider. If it's not, we take that out. We address that through the city code and control it that way. It
that's
makes-
already in the city code though now. Yes.
Yes.
Yeah.
Okay,
And
so
it just-
so the most we might want to say here is election signage will be governed by city code approved by ordinance by the city council.
or nothing.
Or
If
just
that's
say
all
that.
you're gonna say, I would suggest just
We don't
taking
even
11
need
out
that
and
then.
just,
Yeah.
again, that was just there as a placeholder if that was something that the board wanted to consider. If it's not, if you're just gonna, if it's something you're gonna leave up to the council and the city code, we don't even have to state that in the
Yeah, less
charter.
is better.
Um,
Thank you. Well, that actually brings us up then to section 11 through through Article 10 on elections. We skipped a little bit through 7, 8, 9, and 10, but they're pretty straightforward.
Some other things where other municipalities have tried to address election issues is, for example, town of Quartzsite has in their city code a provision that if you owe any outstanding fines or fees to the town, that you're not qualified to submit your application to run for office for
Yeah,
the
but
town.
we wouldn't need to
Yeah.
put that in our charter.
They had issues where someone was elected who had, tens of thousands of dollars outstanding to the town and then tried to get that waived through council action and stuff. So, but that's Quartzsite.
Do we need that, Kenny?
That not fall into the other code in the beginning about fraudulent? I don't remember which section that was, but
In the ethics section.
yeah.
Yeah, that fell under the ethics, and that would probably disqualify them.
Yeah,
At
no,
that
and
time.
I'm just throwing out examples of what other municipalities have done with regard to election issues. And if you guys have thoughts on other things you want to include in the election provisions, again, this is your process. If you have thoughts and ideas that aren't in here, don't feel restricted to what is in this document.
Go ahead, Suzanne?
I think that in section, I just think that there's a lot of redundancy. Article, I think it's for example, in section 1, C, it says council may by resolution or ordinance, provide protections. Special actions, the last sentence says council may order.
Probably going to find a number of those throughout this document because we've tried to take and cut and paste from so many different sources, and you're going to see, well, wait, wasn't that already addressed in a different section? Likely, we haven't done a detailed deep dive. We wanted to make sure that we just got the basics for you guys so you had something to work off of, as opposed to just coming in here without any type of document and then just going straight. Let's draft a section 1. Let's draft a section 2. But again, please don't feel like you're bound by or controlled by what's in this document. If there's things in there that you want cleaned up, absolutely. If there's things in there you want removed.
So I guess my question is more of a procedural question. How do we get from streamlined documents? Do I draft, am I working at, I mean, this hypothetical discussion, like, am I drafting what I think it should look like?
What I'm expecting, just from the staff perspective, is that tonight we're gonna finish going through this whole. As I mentioned before, we have all these notes. Our plan is to kind of put the notes in a unified format, right? So you'll then get a new document where you can look and see, these are the sections that were important to the board, these are the ones that weren't. We had one suggestion of a category of things that we could, which is the procedural stuff. So we'll flag those as we go through tonight, and a couple other things that you want flagged, as a category of things. I think that document will help you a lot as far as organize things or what's in there and what's missing. The other thing that I was thinking, mention this, is that once we're done through the document, it might be an opportunity for people to bring up, well, there's something that I didn't see as we went through the whole thing. And so that could be something that could be added to that next document that comes back.
The past 3 meetings. And you're gonna provide that to us on Monday so that we
Yes.
But
Is that,
I know I just want to make sure, like, clear on the expectations.
May I ask a question? I know in the beginning, we kind of voted down breaking up into working groups. And I think this is such a huge, vast knowledge of big information here. And I think if we dissect it in smaller groups, I think it would be much more clear for these guys. So when they bring it back to us, like this whole section here that we're talking about, like you said, this is redundant, this is redundant, this is redundant. But as a whole, it just keeps growing. So if we dissect it into, if we broke up into 3 groups and dissected and then came back to the group and said, here's what we suggest, then I feel like we can go back to these guys.
that was the original thought. And then there was several members in the group that wanted to go through everything. And there was enough people that wanted to go. We're pretty much going through everything. I think we still have the opportunity to break up into that group once we get this through that
Right,
first
that's what I
pass,
was suggesting.
if we need to get it to that level.
They provide us the document, we come back on Tuesday, we decide at that point, based on the changes and suggestions,
Correct. Yep.
smaller subsections.
Yeah. And we'll give our thumb drives to you today, and then we can come back on thumb drive, or how are we going to get those documents back?
We can email those to you.
Okay,
It's, because
Okay.
it's just going to be a Word document.
that's fine. That's
So
fine.
The thumb drives were because we had multiple
Right.
documents on there, and it would be way too big to attach to any single email. When it's an issue that one document, something that we can attach to an email, we can do that by email, send it to
Perfect.
you guys. And another thing that you guys may want to consider is that when you come back after having gone through all this one time in general, is being very focused as an entire group on 2 or 3 sections at a time, and just going through section 1 and getting all the discussion and all the information out for section 1, and then moving on to section 2, section 3, you know.
That's pretty much what we've been doing here for the last 3 meetings.
Susan, I think these 2 gentlemen, city attorney, when they do that draft, I have big faith that you'll be a lot clearer than like.
Yes. Yeah,
This is right now.
This
So
is
wait,
a lot of
when it comes on Tuesday, I'm like, oh yeah.
Hold on. We want to manage expectations here a bit.
He's throwing it down.
I was going to be typing all week.
All right, Suzanne. Okay, so is there anything else that we want to talk about on the elections right now? With other than the few changes that we talked about, maybe eliminating section 11, cleaning up some of the verbiage. Other than that, we'll go ahead and move on then to Article 11, initiative, referendum, and recall.
Sorry.
Mr. Attorney, did you have a question for us?
Did you have a question for me? Sorry.
I mean,
heard
I take
recall,
it
that
this
catches
is
my-
pretty straightforward and clear cut. I don't see anything that,
Having probably been the only one here who's had a recall petition pulled against him. Yeah. Yes, I was on this, I served as city councilman for the city of Maricopa for 5 years back in 2005 to 2010.
so just,
Pulled that designation as the only person who had a recall petition pulled against him, but they weren't able to get enough signatures.
so just clarification on these articles. These are articles that are in other charters that are pretty much going to need to be required. I mean, you can't just put together a charter and not have that section in there.
Well, and if you don't have that section in the charter, the state statute applies. There are
Okay.
state statute requirements for recalls,
Okay.
for initiatives and for referendums. The question being, do you want to have different additional controls over local matters for recall of city council members?
Yes.
You can establish, if you want to have your own procedures for that as opposed to what's provided for in state statute, then yeah, you can address those specifically as to those matters that are of local concern. But if it's not in the charter, it will likely be in the city code. The purpose for having it in the charter is really what you want to have in the charter is if you're going to have something that's different than what's in state statute. So, and it applies to something of local concern, you want to have that in the charter so that you're able to show to the legislature, anyone who tries to enforce something against it. No, this is what our charter provides. This is what our voters said they want and is of local concern to the city of Litchfield Park. But if it's of general issue, general concern, then my suggestion would be is let's try to make it as streamlined and as simple as possible. If there's nothing in here that's different from the state statute provisions for recalls, referendums, and initiatives, then there's no reason to have that section.
May I ask you a question, Joe? Give us an example, please, of what would be something that on a local level we would do differently from the state?
And if you wanted to clarify better what qualifies for a referendum as opposed to an initiative. I'll give an example that came up recently with the town of Quartzsite. There was a group who filed a petition, and in the petition, it was a referendum on a town ordinance that was adopted that changed part of the town code. They wanted really to change the rest of the town code that wasn't addressed in that ordinance. But the way they worded it, to me, I could understand what they were trying to accomplish, but the legal counsel that they had didn't understand the process. And when it went to the ballot, it had to be classified as a referendum, and it was specific as to just that ordinance that only changed a few words in the code and not that section of the code that group really wanted to change. So that's going to come up again because it overwhelmingly passed. So there was clear community support for the removal of that provision. But because it wasn't, in the state statute, wasn't clear as to defining what a referendum is as opposed to an initiative and different things like that. So those are things that you could do if you wanted to. It's not something that comes up often.
Thank you.
Another one, and this is gonna be more, I don't have a concrete, when this happened. The way I read section 2 in this it says that the mayor and council can submit to the electors at any election. It says any ordinance, resolution, or measure that the mayor and council have the authority to enact. I read that as being very, very broad. State statute reserves ordinances, resolutions, and frames to referendum, right? Any measure, I'm not sure what that means. I read that as being as broad as it could possibly be. And so there, maybe some case law or that says, what exactly that means. It's basically as broad as you can get, right? So if you can expand the scope of what the council can submit to electors, then I think that's doing it, right? Maximizing that. It's a small change, right? It's only 3 extra words.
Kenny, do you have thoughts on that one?
I read that.
so they have a power, right? An ordinance can be referred to the state statute. Yeah, the words in state statute are ordinance, resolution, or franchise. And so here, it's almost the same, right? But it doesn't, it's not limited to ordinance. So I think there's at least an argument that that is what the council can.
It gives the council more leeway. No, it's actually a benefit because what it allows the council to do is if there is something that comes before council that's not based off of an ordinance or resolution, the measure could be like a motion vote or whatever it is, that the council could say, you know what, because there's such conflict in the community and on this issue, we're going to submit this to the voters and put this on the ballot. So it gives them the ability to put more, additional issues before the full residency of the city, as opposed to it just being a council decision.
Chuck, did you have a question?
I do, under the current city code, does it mirror the state statute when it comes to initiative, referendum, and recalls, or anything in current code that's different?
I would have to double check, but I would suspect it doesn't because we're a general law city. So those provisions would have to comply with what the state statute is.
Thank you.
If you want to put a pin in your question for 5 minutes.
We'll get back to you on that.
Okay, well, we can get back to that one and we'll just keep moving through that and go ahead.
Well, one last thing. Do you both like the way this is written?
The whole document?
No.
No,
I'm
article,
sorry. Section 2.
So the vice chair asked if it was bad or what was wrong with it. The reason that language is there is because of different. The reason it's in another charter is because another city. Right. That they wanted law.
I think it's important.
But you're the freeholders, and so it's up to you if you want them that. But yeah, I think it's something that a city would probably.
And I don't think it's very controversial saying that you have the ability to refer more things to the voters as opposed to trying to say,
Less.
or we're restricting what can go to the voters. This broadens what they could potentially submit to the voters.
Agreed. Okay, well, we'll move through that and get to Article 12, Municipal Court.
Mr. Chairman, I didn't have a lot of questions here. This seems pretty straightforward, but I did have in section 5, it talks about having the city council, oh, I'm sorry, wrong section. It talks about the mayor and council having the authority to appoint. I think it's in either 5A or 5B. I can't tell my notes now, but it says they shall contract with the presiding judicial officer in the same way that it said they shall contract with the city attorney. And I'm wondering, do you think that falls under the merit system that's mentioned earlier in the document? I mean, do you think the pay of the presiding judge should be by contract, or is that in the merit system? Because it doesn't say here, it says they'll appoint them, but it doesn't say, and it says enter into a contract. Does that mean they will determine the pay at that time, or is that in the merit system?
For example, it says the council shall enter into a written employment contract with the presiding judge.
For 2 years?
Right.
Do you assume that that means the contract will specify pay?
Yes.
Okay.
Yeah, and the contract would specify, because there's going to be certain provisions, certain positions that are council appointed positions that are not governed by the merit
So
system.
the only reason I ask that is, and I think it's section 4, I think, or Article 4. It says the merit system applies to officers and employees. Are the presiding judge and the city attorney not considered officers?
So I believe the language. You have to have, it has to have a fixed term. I believe it has to be a minimum of 2 years for municipal magistrate. double checking right now. I think it's a state statute. It's definitely in the Supreme Court. But that's not, it's specific to the judge. It's
Okay.
not,
The appointment and the term and all of that.
and the written.
So pay is not addressed here, but in a previous section, it says the merit system will include the pay of officers and employees. And I'm asking, are these not? Okay, if they're not. If they're not, then there's no conflict.
And we can address that section 4 with the merit provision and clarify that to where it doesn't, where it excludes all council appointees,
Okay.
just so it's
Right.
clear.
That's,
Just-
I just want to make sure there's not a conflict.
Yeah.
Okay, thank you. That's all I had on that whole
Chair,
article.
Yeah, Gensel.
Joe, clarify for me, because my understanding is one of the reasons why they probably are not part of the merit pay system is that that requires you to be, to have an evaluation by the city manager or somewhere like,
Well,
and
that,
he is not.
right. And
supervised
there are
in that.
certain, yeah, and for example,
Separate.
the city manager by state statute can be removed without cause. So if he fell under the merit system, you would have to have cause and you'd have to have a process to remove. Same thing with your city attorney, same thing with your magistrate. The difference with the magistrate is there has to be a minimum of a 2-year term, because what you don't want is your city council is your legislative branch. You got your judicial branch. You don't want conflicts where the legislative branch is interfering with the judicial branch. So that's why you have those minimum of a 2-year contract period. So there isn't an issue where you're doing an every 6-month evaluation. Well, we don't like how the judge handled this one specific case, so we're going to address that through this. And it has to be for cause and things like that. So there's a reason why those appointed positions are handled the way that they're handled, to give because the council is the hiring and decision-making body for those positions, as opposed to your regular employees who report to and are under the authority of the city manager.
So everything that you just said makes perfect sense. And when you go to the system that mentions the merit system, it talks about officers.
Right.
I assume the city manager is an appointed officer of the city.
Right, we'll
or the
clarify
city
that.
clerk, the city
Yeah.
attorney. Yeah, so just clarify who's an officer. The word appointed works really well. It just isn't in there.
Right. We'll clarify that, because you have other officers who would be considered other department heads and things like that.
Yes.
You've got your financial officer. There are other positions that could be classified as officer as opposed to just a, employee type.
So I
position.
mentioned this at the last meeting. I've only seen an example of this where the city attorney said, I am appointed by the city council, and therefore everybody who works in my department's salary is determined by me and not under the city system. And we said, well, then they're not protected by the merit system. No, they are, but I get to decide how much they make. And it's just don't want to get to that point of any confusion about who's in the merit system and who isn't.
It's a great point, Kenny.
It says that specifically in
Section
4,
4.
5. Article 4, Section 5. Perfect. Perfect, thank you. Does it say the clerk too?
There's no
Suzanne,
right.
do
There's
not
no
mute the
right.
microphone.
It's not, there is no proper way.
Okay, thank you. Thank you, Suzanne.
These to you. And just for clarification, the 2-year term for magistrate is a case law issue. It was determined 2 years is the minimum. You can go longer than that if you wanted to. It's just up to you how you want to handle it. If you want it for just 2 years, if you want it for 4 years, or however you want to do that.
Is there any logic to maybe 3 years so that it doesn't hit the same cycle as elections or terms? And I'm just wondering.
Yeah, I mean, you could set it up that way so that you're doing it on the off cycle, so it's not associated with or near a time where you have a couple new, for example, you could have every election, you could have a situation where you've got at least a 3-member council changeover.
Right.
So if you wanted that to where it wasn't going to impact that position, you'd say 3 years. So that way it's not going to be associated with a year where there's going to be a council election.
I'm wondering with other city charters though, I mean, is it 2-year, 3-year, is that sort of a standard?
Years is minimum.
Okay,
So anything above the minimum is what you can do. My preference is, 2 to 3, maybe even 4 years, because you want to have that, you want to have that separation between, so the judge doesn't feel like he is being,
we can't write in,
political pressure from the council, because there are times where magistrate judges, especially in small communities, they get somebody who comes before them, maybe it is a council member, maybe it's somebody, a good friend of a council member who got a ticket or DUI or domestic dispute, and you've got elected officials putting pressure, and if they know that their position isn't coming up or subject to a review or determination, they can make a more unbiased decision when it comes to stuff like that.
what about, what about putting a 2 to 4 year term? We wouldn't want to do something like that. Like you said, 2 to 4, or as opposed to just changing it from 2 to 3.
Well, 4 years, you'd have, every 2 years, we'll have the potential for half of a new council. So that's
Yeah.
why I suggested
Well-
3, because it would be an off cycle.
But if you do 3, you're gonna be back on cycle every 2 contracts.
Yeah, that's
right?
true.
Because 6,
Yeah,
so a 2-year contract that was just off cycle would remain off
Well,
cycle.
what's a prime number?
Oh,
That's
yeah.
the question. We need a prime number.
all right, we'll leave it at 2 for now and we can come back to that.
Avondale also has to.
Yeah.
The vast
Maybe somebody doesn't want that 3-year,
Yeah.
3-year deal.
A majority of magistrate positions are 2, they come up every 2 years. But again, that would be the reason for having a longer period, would be as if you wanted to have additional political protection for the magistrates so that they weren't having a review every 2 years. And, that really only comes into issue if you're having issues with cases that are.
Mike,
coming before the
what do you
magistrate.
think? Do we need to change that to 2-year, 3-year?
I was questioning whether we need it in there at all, if it's already established by the state law or the case law. I mean, I guess I don't really have an opinion on whether it's 2 years or 3 years.
So, so I guess a couple, so just kind of flagging, because again, you don't have to have this at all, right? But like, what are kind of the significant things? One thing to put out there is, I don't believe there's anything in state law saying a municipal court magistrate has to have attended a law school or even be admitted to practice law.
Yeah, I've
And
got.
so
we need to have
you're
that.
saying that.
Yeah.
And there are towns in Arizona that have non-attorneys as magistrates. So that's something that that's a choice that you're making when you include this language. The contract thing, I think because it is, yeah, you could leave that out. It would still be the rule. It might change in the future. So if you like that rule, it's a case law rule, right? There's a Arizona court case that says you can't appoint your magistrate for less than 2 years. That could change in the future. So if you like the rule, you could lock it in your charter to keep it forever. But
We could always put a minimum of 2 years
Yeah.
as determined by the council.
Yeah.
The
Yeah,
council
that's-
wants
that-
to give them a 4-year contract, why not let the council do a 4-year contract kind of thing?
We could, that sounds better to change it like that.
I also liked your suggestion about starting it and it was in the document earlier where we started it after. How did you word your statement about it not being an election year? We could go every 2 years.
just off cycle,
Commencing
just
in
a
an off-cycle year.
non-election, yeah, each contract shall commence in a non. But, remember, you have these unexpected situations, right, where maybe the magistrate resigns. and you don't want to wait a year to appoint the next one, right? And maybe the magistrate resigns in an election year and you need to put someone up, and so now their contract's starting. So you could say that the contracts will terminate in non-election years, maybe, like that. So if you're appointing someone in an election year, you appoint them for 3 years. If you're appointing them in a non-election year, you appoint them for 2 years. Try to do something like that.
I think we put in there at a minimum,
Can-
at a minimum of 2
2
years, that
and with the
complies with
council.
what what the case law requirement is, and then it gives that flexibility to the council, because we're already giving them flexibility that, no limit on the number of terms for the presiding judge. And like John had said, one of the main things here is you're controlling and you're putting in standards as to who qualifies to be a magistrate. I've got jurisdictions where, our magistrates are not attorneys. And we've run into that issue with, for example, if you are in a jurisdiction where you don't have enough to have a full-time magistrate, so say, hey, let's contract with the justice of the peace. Well, you run into a conflict there because the justice of peace isn't required to be an attorney. We had circumstances where the city code required a law degree, but they wanted to contract with the justice of peace, but the elected justice of peace wasn't an attorney. So it was either change the code or,
We'll keep that in.
or a number of justice of the peace throughout the state that are not.
Just curious on the section 5 on the D that was added, that needed to be put in from a legal standpoint as far as the magistrate judge with the pro temp.
Just saying the magistrate can add pro temps.
Yeah, and I think that's just with council approval, because you still then, the question is, do you want to leave the appointment of pro tem solely up to the magistrate judge? Or do you want that something to have council approval?
Right.
So, my suggestion is that if your council's going to hire and determine who your magistrate judge is going to be, they should probably have a say as to who the pro tems are going to be.
Right.
And it's not often, just depends. Every jurisdiction's a little different depending on how many times the magistrate's going to use a pro tem. They're used when the magistrate's taking vacation or is unavailable, sick, or potentially has a conflict. You just try to avoid those situations where you have a ton of conflicts and a ton of pro tem work. An example of that was I was a pro tem for Justice of the Peace out in Apache Junction, Sean Babu, and his brother Paul Babu was the sheriff at the time in Pinal County. So he had to conflict himself out from all sheriff department cases that came before him in that. So there was a lot of pro tem work being done. So there are times when conflicts and stuff do come up. I don't foresee that being too much of an issue, but again, you give the council the ability to say, okay, we're going to have a say and sign off on who the pro tems are going to be. It's not just going to be, whatever other attorney that the magistrate judge wants to appoint.
Suzanne.
Example of when the council might need to magistrate judge?
If the workload gets to the point where you need another assistant magistrate full-time, there are municipalities that have 4 or 5 magistrate judges. You have your main magistrate judge, and then you have assistant magistrate judges who are full-time positions, not pro tem positions. It just, if it gets to that point where you have that kind of workload in the magistrate court.
They would not. No. I don't believe they would, no.
Yeah. I would say the sentence that says such additional assistant magistrate judges shall have the same qualifications, judicial powers, and jurisdictions of the presiding judge of
So that
such
would
court.
fit under that same,
That
yeah.
essentially you're saying your assistant magistrates have to follow the same rules and guidelines as your presiding judge.
Paul?
Yeah, Lee, hi, Lisa.
Where we use assistant and associate both, I'm assuming they both are interchangeable. But does it logically make sense to choose one and go with it consistently?
Yeah, we want consistency in that language, so we'll
And
clear
also,
that up to, so
okay.
it's used.
And then also, paragraph, the second paragraph of B, the associate magistrate judge shall serve a term of 2 years and may be reappointed. During such term, the magistrate may be removed only for cause. I think we need to add associate or assistant, whichever one it is. It just could be confusing.
Yeah.
I tend to refer to him as associate magistrate as opposed to an assistant. Because an associate magistrate, an assistant, the word assistant kind of sounds like you're
Clerical.
assisting or kind of clerical work for the magistrate, whereas an associate is more of a kind of like a partner.
An equal.
Got it.
All right, anybody see anything else that jumps out from in that section? Article 12, municipal court. We've been through section 1, 2, 3, 4 through 5. Section 6 and fines, section 7.
I'll tell you from just a staff perspective, I don't really like 6. I don't know. I think I know what it means. I don't really like what it says. Section 6, disposition of fines, penalties, and fees. I don't know that it needs to be in there either. Easy solution.
That would fit under the regular city and
Yeah. One reason for possibly having it in there is, the example you gave of the city attorney who said, well, this is my, I'm an appointed, this is my department, I determine the salaries. You could have a magistrate judge who says, this is my court, the fines and fees should remain here with the court as opposed to going to the general fund kind of thing.
well, that would be a good reason to leave it.
Is it addressed anywhere, Paige, do you remember, in our finance area where that those fees go into?
Sorry, which fees?
Penalties, fines,
Fines, penalties, and fees for
traffic ticket.
It goes into, there's a portion that goes into the general fund, but a lot of that goes back to the state, to state funds.
So every fee or fine that a court collects is established somewhere. And so the city establishes a lot of fines and the state establishes a lot of fines. All the state fines, whatever statute is creating that fine says exactly where the money's supposed to go. City fines should also do the same, right? Each time, so the council creates a new fine for the court to collect. They usually say, where that money's supposed to go. I guess they don't technically have to, they should.
Or you could,
Thank you.
you could have it say something like all fines, penalties, and fees collected by the magistrate court shall be paid or otherwise dispensed pursuant to city code. And you could
Yeah.
leave that up to city code to be able to address any issues that could come up so that if there is something, again, you have that flexibility to address it. I know, I've seen in other jurisdictions where if there's, for example, in addition to the fines and penalties, you have surcharges and assessments and court enhancement fees. And, you know, you could have a $100 speeding ticket and it could end up being $300 with all the add-ons.
Court.
So everybody likes to add on to those charges. So if you keep it as general like that to where you still have that flexibility,
I think leaving and then adding that per the city code that you talked about. Chuck?
On section 7, paragraph B, the second sentence, the police of the city. Is that language broad enough to include the fact that we have a contracted police force in Litchfield Park?
yes, because we contract for that service. So they're still the city's police force because we contracted for them.
Okay.
Whether we do that through Avondale or any other source, or eventually if the city wants to go in-house and have its own police department.
Mhm. So it doesn't limit us in terms of
No.
which, how that works. Okay, thank you.
That doesn't mean you can't tinker with that language
Yeah.
if you don't like it.
If there's a way you want to clarify it, you know, or if you think it would help to be
Acting,
clarified.
acting police of the city.
I wonder if it might be good just to include or contracted police force. The police of the city or a contracted police force, just to button that up.
Talking about where it says police city.
Right.
Yeah.
Yeah.
So police officers have statewide jurisdiction, right? And they're sworn and certified and authorized statewide. So, but I think that's a fair point, is what does police of the city mean in the context of? So we can look at that and see if we can think of some suggestions for different ways to address that. Right. Right.
Yeah. You want it broad enough to where it covers both
Correct.
circumstances.
Because it just says the police of the city and that whoever our police.
I mean, don't they already have the jurisdiction to serve and
Yes.
execute any writs and processes issued out? I mean, is that redundant language?
I
Do we
think
need
one
that?
so police are authorized to execute and serve stuff coming out of the court, right? They all are. One thing that might be significant is the directed, authorized and directed, saying that the police of the city need to be, taking these writs and processes that the magistrate issues. That might be significant.
And there are some departments that don't do that. They will say, nope, you've got to take that writ, or you got to take that to the sheriff's office or to the constable. We don't serve service of process. It just depends on how that department is handled, because that can take up additional time and resources and things if you're having your local PD serving those service of process matters.
So the word directed might be doing some lift in there.
Okay. Anything else on that, Chuck?
Yeah.
Yeah. Anything else, A, B, C, and section 8, moving on to section 8, before we finish that article?
Just clarify, can I ask? just
Yeah,
a
Lisa.
clarifying question? So does that mean that statement we were just talking about, does that mean that Avondale Police Goodyear Police can't come in and serve a warrant, or does it have to be done by our police?
Well, there's a difference between a warrant and service of process.
Oh, that's true.
For example, there are civil service of process things that have to be done by the sheriff's office or the constable. They can do it, just do you want to require them to do it or give the department that leeway to do it kind of thing?
And I had a follow-up thought about that. With us, as small as we are, and we've contracted with our police protection, we have 2 officers on duty at a time, at every moment of the day, 2 officers. I don't know that I want them out serving papers. I think I'd rather have them doing legitimate policing. Is there a way of taking that line out without, I mean,
Well,
could
remember,
we,
this
instead of
is,
saying directed, just say may execute and serve? And that way, if they have the time, it works. If not, they call in the magistrate, or who would it go to next?
well, so I don't have the working experience to tell you how much process is being issued out of our city magistrate court. But I guess I would point that out as, I don't think this is something that would take their entire day up. I think this is probably relatively minimal.
Yeah.
I don't know if there's anyone else here who has more
I mean,
information.
one of the benefits of having your local PD being able to do that is it's coming from the local magistrate court. So the local PD are doing it as opposed to them saying, well, you just got this writ from the local magistrate. You just got this order of protection that needs to be served. Okay, go find the constable or the county sheriff's office to do it, as opposed to go to your personal local PD to serve this order of protection kind of
I
thing.
think it allows us to stay local. It might be a good thing to keep.
The order of protection is a great example. It can be a big hassle for a victim or someone who's got an order of protection to get it served. That can be difficult. And so I know to them, it would be valuable to have in order to the local
Yeah.
police that they have to go help them serve that. But, again, is that something that you want in Litchfield?
If you want, we could remove the 2 words "and directed" and just say the police of the city are hereby authorized to execute and serve.
Right.
Okay.
And that gives them that flexibility to where if for some reason there were an issue.
Good.
I'd rather that.
Yeah, that sounds good. We can see that in the next.
And I think that
draft.
would also probably help with any potential conflicts where if you had somebody who was coming in and getting an order of protection against an officer of the local PD, instead of directing the local PD to serve that, you have the option of going to the constable or sheriff.
Yep. All right, we're a little over an hour into the meeting. Are we pretty much through that Article 12? Any more thoughts on that? Does anybody need a break? There is food here if somebody needs a break. All right, let's go. We'll do like a 5-minute break.
Keep drinking too much
Yeah.
soda.
5 minutes. Thank you.
Terry, do you have an extension cord?
I bet. I think he just did. Yeah, I didn't love what he did either, but I let it go. I am providing assistance, so I guess. Nothing. I was actually, that's why I kind of looked at it. I don't know how many things are coming out of our court. I did a look around. Somebody here knows. Jump in and say, what? I don't know, actually. I don't believe he is. I don't believe he is, but he's a former council member and a former municipal director. But I don't believe he's. Actually, I don't know if Susan is. It's a bad place to. There's more than 2 attorneys in this room. That's what we were just talking
As soon
about.
as you put that in front of my face, I'm like, yeah.
Oh, you taking off?
Thank you for letting us observe.
I know. It can take up to 2 years. You were saying that sales tax on rentals was going to be discontinued, and I have a friend that works for the governor, and so I asked him because I'm in property management. And he said she vetoed it, but then they rewrote it, and she approved it. So is it going away or is it not? Okay. Well, I mean, you're doing it alone. That was substantial. Yeah. You know, I don't understand the logic there because the private landlords that are renting their homes, they're paying into that. But these huge, property management companies that are running these apartment buildings and they don't have to pay that, charge that anymore. I don't see the logic. The landlords just make more money because they're not lowering the rent. Yeah. Yeah. No. They're like, great. Yeah. Makes my place more appealing.
Really tight as.
Where'd you get that really good?
It is tequila. And there's over a piece of one. You can go to 2 times. I got it. One meal, my favorite from earlier today. It's really tight, it's in the immediate future. You seem to say. It's like a mole and all the, that was level. And Marcus. Yeah. Every single thing. Including the assistant versus associate.
Oh my God.
Rules. No, I got it. I got it.
Now we have to call it associates.
Got that one, that's right. Hard to say. I would say it's probably nothing to be inferred from that. They're tiny. Or the 2 staff members are just doing something else.
Okay, I think we can go ahead and get started. Keep eating. Thank you so much for the food. So I believe we are at Article 13, franchise and public utilities. And these next several articles in a row seem to be pretty straightforward as well. So hopefully we can get through these relatively quickly and then get our edited version and keep moving along. Kenny, anything on Article 13, franchise and public utilities that jumped out to you?
Chair.
So
In section 2, where it says the city shall have the power to own and operate any public utilities. I know we're having a problem with our utility right now, but I don't know that we can ever own one and operate. But just by saying we have the power, is that like somewhere down the road? if we're able to have enough finances to actually operate a utility company, that's why that's there.
It gives you that option, that authority. It doesn't require you to do anything more. But there are many municipalities own and operate the water, wastewater utilities. Page, for example, even operates the electrical utility. They operate all utilities except for trash service.
So if we did not have that in there, then we would not have the ability then if we decided to purchase one or.
Cities still have a statutory authority, but this kind of puts it there in the charter and says the city has this authority.
Yeah.
And that's not to say that just because you have the authority doesn't mean it's not going to cost you. If the city were to, for example, go and condemn a water utility and take it over, you would still have to go through the legal process of determining the value of that taking, because you're going and you're taking property from a utility company and converting it into a city utility. So there's compensation that has to be paid. But again, it gives that authority because those are typically you want your city to have authority over the basic core elements and necessities for your city, your utilities, your police, your courts.
Anything, Sonny? That's good.
That's all I had on that.
Lisa, do you have anything to add? Okay. I think we're good on that. As far as Article 13, establishment multi, that's good. Anything else? Anybody? Otherwise, we'll move on to Article 14, general provisions. Do we get liability insurance here for this? Just,
Are we covered?
are we covered? You think, Mike, on that? Looks good.
I think you could just cover all of the articles and ask if anybody has questions. It's all such legalese that there isn't a lot of.
Right.
Is there anything in there legally that we need to do, or you would like for us to consider change on? We'll go through them one at a time here, though. So in terms of Article 14, anybody have any questions 1 through 8? And there's nothing we need to change legally on that at this point?
Can we scroll down? My computer died. Thank you.
I'll just say that the city charter review, I like the way it's worded, to just give the council the kind of heads up, like, you might want to consider looking at this every 10 years. But
Yeah.
if you're really busy at that time, and this is required at that time.
Just, yeah, yep.
There are some that do it every 5. It just,
I don't know, I don't know there needs to be every
the way
5,
it's
yeah.
worded, it gives you that flexibility. You could do it every 5 if you wanted to.
Good, then let's move then through into section 15, definitions. That was pretty clear. Anybody have anything on that? Good. And then just moving right into 16, succession in government. Terry, this is all pretty straightforward in terms of on that, yeah. Anything, Suzanne?
We haven't gotten to Article 17 yet, right?
No, we're 16, just anything on 16? Like I said, going once, going twice. Actually, that's fine. We can move on into, did you have a question on 17 amendments?
I just thought it was kind of interesting the way it was worded, because we've had so much discussion about what we would have to do if we amended this charter, that this just seemed very like overly broad. Am I the only one that thought that?
I expected it to say it requires a vote.
That's what I was expecting
mic
too,
on.
so I,
What was that, Kenny?
I expected it to say it requires a vote, a public vote, in order to amend the charter.
Which is
yeah,
what the Constitution requires. And I guess the thought behind that, just like not referencing statute, is that if the state constitution were changed, likely it wouldn't. You would have to come back and make amendments to your charter. But if you wanted it to say that, that the charter may be amended as provided by the Constitution of the state, which requires a vote of the qualified electors or something like that.
I think that would be
Yeah.
good.
Can we add that to the vote? All right. So at this point, we can, if there was something that anybody thinks could be added or maybe should be added, basically a separate article, or something that wasn't discussed earlier, anybody want to bring something up? Kenny? Yeah, grab the mic there, make sure you're on.
So bear with me. These are kind of going to be long-winded, but I just want people to consider this. And if we don't want to consider it, it's fine with me. But I think that, think about what people are going to be looking at 50 years from now, and they expect to see in the charter. Charters that were developed in 1900 probably don't mention a lot of water rights. I think water is the future. I think it's going to be the big fight. And we might want to consider addressing water in here, but I have so many questions that I don't even know what to propose. So let me just throw some things out there that are rattling around in my brain that I think an attorney, maybe even a specialized water use attorney, might have to comment on. So a million years ago, when I was a council member, the water company was Lipsco, Litchfield Park Service Company, who was a subsidiary of Penn West. Suncor was also a subsidiary of Penn West, and Suncor was building houses to the south in Goodyear, and the Litchfield Park water rates were going through the roof. And there was a rate case at the Corporation Commission, and I was one of the council members who went down to testify to say, wait a minute, all of Litchfield Park residents' water rates are going way up. And that's because you're undercharging Suncor for the hookup fees down in Goodyear because you own Suncor and you're making a huge profit. Corporation Commission agreed. We won the rate case, right? So that's a private water company, Lipsco, who was operating that utility. other things, and now we have Liberty, who came from Canada, I think is a Canadian company, who bought out Lipsco, right? So I have questions about the whole operation of our utility, and here are some of my questions. So Buckeye recently temporarily gave permission to a developer to begin building without having a 100-year water supply required by ADWR, Arizona Department of Water Regulation, whatever it is. They didn't have a permanent in place. And now Buckeye is reneging on that and saying, we are not going to allow you to develop because you don't have a 100-year guaranteed water supply. Does a city have to have a 100-year water supply guarantee? You don't have to answer these. I'm just saying, I need to know that before I decide what goes in here. And if a city has to have that, and let me just say before you answer.
I'll tell you really quick, the city itself for city property, no. For example, the issue with regard to City Center, Litchfield Square. We were able to do that and plat that as a platted subdivision without the water requirement, whereas if a private company owned that, they would have to go through and get that private.
Okay, so is there a statutory requirement for cities to have a designated water supply in their city?
I do not believe so.
Okay, so East Valley cities like Chandler and Gilbert and Queen Creek are buying property in northern Arizona from farmers just to get the water rights so that they have sufficient water to serve their residents in the years to come. So they go buy farming property up in northern Arizona, they buy the water rights, which allows them to pump more water out of the ground down there. And why do they do that, I guess is my question. Why do they buy water rights if you don't have to have guaranteed water rights? Because they don't have enough water to provide for their citizenry, right? They want to make sure they have water for their citizens.
Or they're purchasing those rights so that they can expand what they currently have.
Whatever, yes, so that they can expand, and whatever their future customer base is, they will have enough water to supply to those customers. So they're doing that. So a city like Litchfield Park, who owns the water rights that Liberty Utilities is sending to Goodyear and Litchfield Park and County Islands? Who owns the water rights?
I'm not sure where Liberty Utility gets their water source, if it's through a well system that they own personally, or if they purchase it from other sources.
Okay, so this is really important to me. If the city of Litchfield Park doesn't own water rights, what happens in the future when Liberty says, we're going to serve customers that are being built to the east? Sorry, Litchfield Park, these are our water rights. You don't have water rights. You don't get any more water. We have to put something in the charter that guarantees water for Litchfield Park residents. So,
well, I think they're required to service the current. So the question would be is, do you think Litchfield Park is going to have substantial growth in the future that's going to require substantial additional water?
No.
They're required to provide that service, both water and wastewater, to current issues. And we have had that issue come up with on the wastewater side, where Liberty has said, we do not have capacity right now to allow any additional connections to our wastewater system.
right, so if Litchfield Park doesn't own the water rights and Liberty does own the water rights and Liberty promises more than they can deliver, do we just take it in the shorts like all of their other customers? They say, we know we promised you, all of your existing residents, that you would have water. We've gone too broad. We don't have the water. The well has run dry. Sorry, you're out of water. So other cities are addressing this by gaining water rights. They're buying water rights. So I don't know if the city of Litchfield Park through Liberty has a designated water right specific to our city, not just the utility.
I think those cities that are purchasing those water rights have and own the water utility. We don't. So I think you would have to be you'd have to be in a certain situation where the city would either have to buy out the utility to be able to establish.
Is
So
that
I don't
something
know.
that we could even put in the charter?
So, yeah, I don't think I've had my question answered. Who owns the water rights that utilities, that the Liberty currently pumps water from? Who owns those water rights?
Like I said, I don't know if Liberty owns their own wells or
Yes.
if they purchase it from
I
someone
need
else.
to know that before we address this in the charter. If we have water rights, then we need to address our water rights in the charter.
I do not believe that the city owns any water rights.
Okay, can you find out?
Mhm.
Okay, so that's kind of my first question. And so, and also, I think, I don't know if you all noticed, the legislature required, revised statutes required that any new development produce an ADWR, is that right? Arizona
Department of Water Resources.
ADW, provide a 100-year certificate from them before they were able to develop. And then one of the legislators, I think it was in Mesa, said, you know, that's really strict, and that 100-year water supply requirement is kind of arbitrary anyway. I think we ought to take that out of revised statutes. Let's just eliminate that. And you can allow people to build whatever they want to build, and they don't need to get the 100-year. They actually, it didn't pass, but they actually proposed that. So can the city of Litchfield Park say no development shall occur in the city without a guaranteed, without a, whatever you get from ADWR, certificate guaranteeing a 100-year water supply? Could the city do that?
Well, the trick about what you're specifically talking about is, you know, if the legislature were to repeal that requirement, they would probably repeal the certificate program, right? So ADWR wouldn't be issuing those.
Then we wouldn't have any new development because our charter says you can't have any development without a certificate. That's what I'm saying. We don't want to contribute to the situation that's going to occur in the future where there is not enough water to sustain the houses that have been built, right? So I just want to explore what we can do. Can we put something in here that says you can't develop in the city of Litchfield Park without a 100-year guaranteed certificate? If we can put that, then we'll talk about it. But I don't know if we can. I also, you know, again, reiterating this, I think it's terrible that the city doesn't own water rights anywhere at all. So we're, you know, that utility says they'll serve our customers, but that utility keeps expanding and expanding. And if other cities are allowing their housing to grow to the point where they just don't have enough water, how do we know? Maybe we put something in the charter that says we require the utility that serves Litchfield Park to provide us with a 100-year guarantee certificate from ADWR, guaranteeing that they have enough so that they can't expand beyond the scope. So cities that run their own utilities do that. They say, we know for a fact there's not enough water for that development. We're not going to allow it to occur. Here we are in Litchfield Park, hoping that the utility that manages our water is imposing that upon all of the entities that they serve.
Could there have been something in this charter that would have prevented problem that we have with the affluent, with the, could that have been built in already? Let's just say we had this charter built in. Would we have not had this problem then?
Off the top of my head, I wouldn't be able to answer that question just because I would want to look and see what type of additional requirements we could put on a utility that is regulated and controlled by the Arizona Corporation Commission. Because there's certain things that, you know, that is the regulatory agency for those utilities. And I don't think that the city has much in the way of rights or abilities to say, regardless of what this regulatory agency that has complete control over you says, we can impose additional requirements. I don't know if that's something.
And are there any cities that have these charters that say in there that each new development must meet this 100-year water
I
right?
have to go back and look at those charters, but
Did you see any of them?
I mean, I wanted to let Joe finish his statement, but I don't think that this is something that we can put into a charter. I don't think we can legislate that. Like, I think that I get what you're saying. We definitely want to be resilient when it comes to our water because like City of Phoenix, they're looking at all these different, you know, all these different handling potential water shortages and things like that. And I don't know how resilient Litchfield Park is when it comes to that, probably because I suspect we don't have the water rights. Otherwise, we would be operating our own utility probably.
So let's start with something that's simple. And again, I'm not proposing something.
Yeah.
I just need answers so that we can discuss it. You know, I don't want somebody 20 years from now to say, how the heck did you develop a charter and not address the water rights and now we're all out of water? So if the state statute currently requires all new development to have a 100-year certificate, which they do, if we put that in our charter that said development within the city of Litchfield Park will require a 100-year certificate in order for development to occur. We're not overstepping, we're not doing, but then when the knuckleheads down at the legislature say, let's just waive that. We don't need any stinking water. Let them build whatever they want to build. Our charter still says, well, you're not going to do that in our city, right? So I think there might be steps we can take to at least say we're trying to make sure that we don't allow development on our city that can't be served by the current water supply.
I don't think though that the water supply is the water supply, and whether we let it or not, nobody can guarantee it. Like we can put it in the charter, but we can't guarantee it unless we,
WR can.
So can,
They can say yes.
until, yeah.
Yes, yeah, well,
if I may, I looked that up really quick. And in 2004, when the village at Litchfield Park was developed, they have a recorded document in the matter of certificate of assured water supply to the village at Litchfield Park. And it was recorded and signed by Cabuto and Suncor. And then, of course, the Arizona Department of Water Resources. So they've forced them
to comply.
And
Yes.
I think that's all you're looking to do is just add a sentence in here that any future development, any future residential or commercial development shall receive this document.
Right,
I
so,
guess-
so right now, if we don't have that, we assume ADWR will just do that. They will require them to have that.
Well, it's a statutory requirement right now, but
Right.
your concern is that if the legislature decides to change that and
Which they
you know,
tried to do.
right. The question there becomes, regardless of whether it's in the charter or not, I think the legislature is going to make an argument that the water source and the water resources are of statewide concern and that a local municipality cannot.
Whoa, no, we can't allow them to go beyond the 100. We can't say, you can build in our city, even if you don't have a 100-year water supply. We could never do that because there's legislation. We can further restrict though and say development in our city requires proof of a 100-year water supply. The legislature isn't requiring it anymore. We are.
Right, but then the question would be, could you right now say any development within the city would require a 200-year water supply?
No.
Because there is a
Oh,
way
I
that
see-
you.
yeah, I see what you're saying.
Yeah, because we're at 100-year right now.
Right.
If you were to say, could the city require a 200-year water supply certificate right now? We would have to do some legal research. I don't think that
But-
we could be that
So
restricted.
all I'm saying is I want to be on the side of having that in our charter.
Right.
And when the legislature does something stupid and we're one of the cities signing on to a lawsuit against the legislature for ruining our water supply, we say, look, we included this in our charter. We're a charter city who had the forethought and foresight to put that in the charter. And we have a good fight here. But I don't know the answer. If we can't put it in, we can't put it in.
Is that, maybe that's something you can look at and see if it's even doable?
Yeah, we can look at anything you guys ask us to look
So,
at.
so just to be clear, we're a city sitting here with no water rights, right?
Right, because you have no water utility for the city.
Part of the issue is that you're not actually talking about, look, I own 8 ounces of water, right? You're talking about the right to pump and to distribute water. And so you're talking about not just do you own water, but you're talking about the concept of service area also, right? And so some cities do have designated 100-year water supplies, but it's specifically, so they're designated as water suppliers, they're service providers. So for example, the city of Phoenix provides water. And so the city of Phoenix has been designated by ADWR as a service provider that has an adequate supply to serve its customers, right? We're not, the city of Litchfield Park is not a service provider. So that kind of 100-year designation isn't available to the city itself, which is why there's another rule, right? When you're not within the service area of a designated provider, the development, right? And this is mostly for subdivisions, right? I think it's 5 or more lots have to provide their own certificate of shared water supply for that development, right? So this is a really good conversation and we can look at what angle of approach you have in it, right? But it's not, because it is so tangled up with the concept of a service area, and Joe's talking about the statewide concern, right? I think, you are, especially when you get into the service areas and water providers, you probably are running into those concerns because it's not just ADWR, but it's also the Arizona Corporation Commission, which is, so Liberty is regulated at the state level by the Corporation Commission as a service provider, in addition to being designated when it comes to this water supply issue, in addition to being regulated by ADWR. So,
Okay, so all of these are really good points, and I think you've convinced me that we couldn't put something in here that says our water provider shall provide us with a 100-year written guarantee every year. We can't do that because they're already regulated by the state, right? What we can do is regulate development that occurs in our community that hampers their ability to provide that water. So if we say, look, you can't get a 100-year guarantee from ADWR, don't come here. We don't want that development. We can control development within our city. We can't control the water company who provides the water to the customers, but we can control the number of customers. Right?
Yeah, but I think looking at Litchfield Park specifically, Litchfield Park is landlocked. There's not a substantial amount of developable land within Litchfield Park. So I think that the questions and concerns that you have with regard to growth and issues are addressed to a utility that we don't really have control over. If you want to establish the type of control and the ability to know that you have water rights in a designated source, that would be something that the city would have to look at as to acquiring and being a service provider. Because all those other cities that you've mentioned that have acquired water rights outside of their jurisdiction, Queen Creek, Buckeye, all of those are service providers. They all provide water service,
Right.
whereas the city of Litchfield Park doesn't.
So-
We're reliant on Liberty,
Right.
just like we are with the wastewater. If they don't have capacity, how does that impact the city?
Right. This has been a great conversation. I'm not proposing anything. I just want some information.
Is there,
And that
is there
gives us
something that
information
could
we
be
can
put
look at.
together?
Let me just say, if I just produce this scenario, the legislature just removed the 100-year requirement. A big development wants to occur here on this vacant land. And they go to ADWR and they say, you don't have enough water for that in your utility. Will we say, yes, go ahead and build it anyway? Or will we say no? That's my question. I want the ability to say no. That's all.
I know, and it's a great conversation, and we have a lot of
We'll look
information
at
that
it.
we can go look at and try to.
Maybe
bring
we
some
can,
back
we
to you.
can, you can come back to that. We can,
Yeah.
a specific
Because these
issue.
are going to be very
Yeah.
specific, very detailed.
Whatever you think
Focus
we can do.
areas.
I just think this, what is the rest of it? Do you think we should even look at the water? I mean, this is going to be an
Yeah.
issue, isn't it?
Like, what does the city actually own and have rights to? I think that's fair.
yeah, the challenge for Litchfield Park specifically is that this whole concept is so tied up in utility service legally, right? I mean, that's how it's regulated, and growth, like Joe's pointing out, right? And so a place that's not a water provider and that's not having a lot of growth, and then it doesn't mean you can't do anything about water, right? But what we're saying is those are two of the really important key concepts that are gonna kind of control what you can and can't put in here. So while
That's
you
right.
think about it, we'll think about that and see what we can come up with, but, think
Okay.
about
Is
those
that, do we
concepts
need
too.
it? We don't have to have any sort of a motion to have that
No,
kept
no,
on the agenda or any of that,
This-
no.
We can take it on as staff direction to look into these issues.
Was there anything else that you?
I only had one other issue, and it's land use. So, let me think of the best way to phrase. So, in the city of Tempe, the Papago Mountains are part of the city. They're in Scottsdale, Tempe, and Phoenix. Phoenix Zoo is in the Papago, all of that. And there are really strict zoning codes in there. But every year, some developer would come to the city of Tempe and say, what would be really nice up in those Papago Mountains, a nice big hotel, or something like that. And the residents started getting nervous when council members started putting things on the agenda. These guys said they'll make it look just like the mountains. It's gonna look like Sedona up there, and they're gonna build a beautiful hotel. And they ended up having their first ever charter amendment where they went in and designated that as a preserve, so that they cannot build in there. So future council members who get wined and dined by developers who want to come in and put a hotel in Papago Mountains won't be able to do it because now it's been designated as a preserve. So we have land up that the Litchfields gave us and gave to Sun Health. And I called the director of the Heritage up there, and she contacted the board president. So I just didn't want to blindside them. I said, I'm going to bring this up at a meeting. Is there anything that these folks in here want to do to make sure that that's protected in perpetuity, that some future council doesn't have the Paul W. Litchfield Walmart up there? Is there anything we want to do with the city? And the question is, for the city manager, I guess, what protections are already in? When they gave the land, they put protections in there that says, you know, Sun Health will get that, and we want to preserve a museum and things like that. So if there's anything we need to do to make sure that future councils don't think that's a really good spot for a McDonald's or a Walmart, I would like to at least get your all opinion on that.
Lisa, can you
I
comment?
have a comment on this because I'm involved with the Heritage Center as well.
Do the mic too.
Oh, sorry. That land, when it was donated or given was as a gift, was very clearly laid out about what could go there and what couldn't go there
Okay.
as part of the gift. And it's part of our general plan, correct? It's
Yeah, it's
in the
designated in the
plan. So
general plan
anything-
as a specific.
Anything that we would want to do would have to require a general plan amendment or change.
Right.
And that's a process that we look at those every 5 years.
No, you can do a major general plan amendment can happen once a year.
But we
But
review
that
them.
is,
we
that
re-
is something that could happen, that the council could do a major general plan amendment. The general plan itself is looked at and amended and updated every 10 years.
10 years.
So I'm only looking at preserving the legacy of Paul W. Litchfield. That's all. And if it's solid now, I'm good with that. But I want to see what is in place. If it's something that the city council can change.
It's pretty specific. It's pretty specific.
I'll give you an
can't put
example.
a bar up there. You can't put restaurants up there.
Okay, I'll give you an example. That property in Tempe was given by President Roosevelt. And it said it can only be for municipal uses. And they got very creative and said, we want to build a hotel, but the city will own the land and we'll just own the improvements, and therefore it's a city hotel and it'll be fine. And I don't ever want to see that happen up there. So whatever you can bring us that says these are the current restrictions, if the board's happy with it, I'm happy with it.
Do you think we need to
just wanna
put
make sure we-
something in the charter, Lisa?
I think it's covered by zoning.
I think what you're asking is to change the general plan, and you can't just change that.
Oh, yes, you can.
So I mean, there's a process, but I think
You
what
can
you're
make a
saying is.
major amendment to a general plan by ordinance.
What I think Member Jones is saying is this, is there something in the charter that we can do that better protects it, that
Protect it,
a
yes.
rezoning could be approved by council. A
Mhm.
major general plan amendment could be approved by council. Something that a council who would be subject to potential pressures from developers and things to be able to put in those protections like they did in Tempe and say it has to be reserved as a preserve, or, you know, no commercial development, different things like that. Something in the charter that gives the voters the control over what does or doesn't, in addition to whatever deed restrictions may be.
And
on
any
that.
change would also require a vote.
Right.
So if in the future they wanted to put a McDonald's up there and the voters all approved it, they could do it. But that's all. I'm just looking to preserve that. But again, I just need to see how it's currently protected. And does anybody disagree that that property needs to maintain
Yeah, I
the
like it.
legacy of the Litchfields?
Missing it. So once, let's say we change the zoning, council change the zoning, then it's done.
No,
But you're saying you want a second.
zoning can get changed every year.
Okay.
Yeah, the zoning could be changed by this council, the next council, future councils. What he's saying is something that's in the charter, if there were a change to whatever the designation would be or restrictions would be in the charter, that would have to go
be a
to the
vote.
voters for approval, as opposed to just a council vote where a four vote could make a change to what's
Yeah,
done.
I like it.
Language, some legal language that Paul Litchfield's heritage will remain.
Whatever the city manager in concert with the folks who run the property up there, the heritage, and the,
Yeah.
there's a
the
board.
Litchfield Heritage
yeah, there's a
Center.
board, there's a CEO. I mean, and just the city manager get together and come to us and say, we think this is protected well enough. Look how well it's protected. Okay.
Or if they believe that we
Well,
could
the
put
Heritage
something in.
Center is, can speak to this because legalese better, but we are basically tenants up there. We don't own anything. The city owns the property where the house sits. Sun Health owns a large portion of the property, correct?
Yeah.
Not on the hilltop.
Around it,
Around
around it. And so the project, I don't know if you know what their plans are, but they're right now in the plans are to expand the museum up there. We're going to do it in phases now. So phase one will be using the existing building, and phase two, when economic conditions are a little bit better and we've raised enough money, we will do phase two, which will include archives below, if you know where the pool is.
Yeah.
In that area. Down on the area down below, the land below the hilltop, there's talk of, or there are current plans to, let's leave it that way, to bring the railroad depot in that belonged to Avondale, I think, or maybe Goodyear. Goodyear, thank you. And that'll go there. There's a group of people who, from Farm and Ranch, which is another historical type association, that are going to be doing that. And we'll make it a museum of sorts.
Right.
Well, I just think
There's-
we need to look to see, do we need to have something in there to protect that?
Council and previous councils have done a great job of maintaining the legacy. I just want to make sure that,
Yeah. Okay.
we run into hard times and we think revenue generating Walmart up there would be a great idea.
So,
Land, the way it was donated, was designated and called out that if we stray from it, we lose the property.
We'll look at what the deed restrictions are and requirements are, and then we can bring that back. to-
whether it needs to go in the charter, that, great.
That's the only two I had. Thank you.
Okay. Does anybody have anything else they want to add to the current discussion? I just wanted to bring up on the next item on the agenda for the postcard proposed charter. Could you just go through that one more time, what the plan is on that? What,
The reason this was created was to save on costs and to provide the residents way to view the entire draft charter rather than creating a publicity pamphlet and mailing it out to everyone. That would cost enormous amounts of money. This would go to every registered voter and the cost is very minimal. I think it was like $1,000.
and that's going to be provided by the city just as a notification that this is going on?
Yes, I'm working with Runbeck Elections, or will work with Runbeck Elections to print and mail.
Terry, is this a good time to give them kind of a briefing about timeline and what we've been finding out about?
Sure.
Sure.
Go ahead.
So you have a whole bunch of statutory restrictions on the time that you have to work. I think you talked about all this on the first meeting, right? But you are required to propose a charter, finish it in 90 days. But you also, the charter has to be published for a certain period of time, and the publication has to occur a certain period of time before the election actually happens, and the election has to be on March 12th, right? So counting backwards, right, you have to be done in enough time that you can complete the publication that you're required to do. So Terry has been working, and Joe too, have been working directly with Gannett, that publishes the Republic, trying to talk to them about what the options are for publication. And it sounds like the absolute hard deadline that this is gonna have to be at a printer is gonna be January 22nd, but it's probably gonna have to be the week before that. January 16th is probably a realistic date that you should have in your mind that you're gonna want a charter that can be on the desk of a publisher.
And I believe that the mayor told them their drop dead date to submit was January 16th.
Yes. Yeah. We're going to be done and ready to vote on it before then.
Yeah, we were hoping, we were hoping to look into seeing if we did it as a slip copy or some other type of process with the paper, if that would give us additional time, but in conversations with the paper, that actually takes longer for them than to just include that with their digital typeset and include it with their run of the actual paper, because they have to have stuff available, set up, because then there's additional collating that has to be done to put all those slip stuffs into the actual paper as opposed to just it being printed. So we're in the process of trying to get an estimate as to, the cost is what the cost is going to be. We have to publish it. It's a requirement. We're trying to get an estimate as to that. We've given them the draft charter for Goodyear so that they can see what a charter format looks like, and, the number of words and different things like that. So we can have a good idea as to what that's gonna
We'll be
cost.
ready. I think if we can get these amended, the changes that we made in the email, we'll get those by Monday. You said we'll have an opportunity to look at those.
Well, John will have those to you tomorrow. Yeah.
That's fine. And then we can, we'll have we have our same meeting here Tuesday. We should be able to get through that.
Yeah.
And then I think we're getting pretty close. And then the only thing would,
We have a lot of things that we said, we're gonna go back to that.
That-
We're gonna go
Agree.
back to that.
Yeah, there's quite a bit. So the postcard is tied into that idea of the schedule, right? Because, so Terry mentioned Runback Elections. So they provide, so they print publicity pamphlets that you've probably seen for initiatives or things that have been on the ballot in the past. Joe was mentioning the collating, which apparently is a very lengthy process, time consuming. It's even worse for the publicity pamphlet. So if you wanted to do a publicity pamphlet the way you normally would, you would have to be done. I mean, you would have to be done like next week, 2 weeks. It'd have to be in December. And so we're not, it's just not going to be possible. So the concept of this is that whenever it's done, we'll put it online. We'll send out this postcard. People can go online and pull it up, or people can go to the clerk's office and pull it up. And so it's our way of getting the information and getting the charter accessible to people without a 2 or 3 or 4 week delay, while a printer, whether it's the newspaper or whether it's an election company, is, collating or whatever else it is that takes so long.
Suzanne.
Can I just make a motion that we approve the postcard for mailing for the charter? I don't know if I did that right.
I'll second.
Thank you.
Is there any other discussion?
What would be helpful, in just a suggestion in your motion, is if you approved, the postcard in substantially the same form that it's in right now. That way, if there is a little thing that needs to be tweaked. that
Can
they
you write it out for me and I'll say it? Okay, let me see if I can do this right. I would like to amend my motion to have the postcard mailed out in substantially the same form and as it's been presented here, and Terry will be the one to handle it.
I'll second.
Any further discussion?
I have a question on our timeline. I thought that when we started this, our goal was to have something ready to go to them by Christmas.
Yeah, we will.
Heard that.
No?
I think Matthew mentioned that, but, whatever you guys have to us, when you have it to us, we will deal with it.
Yeah, you're in charge.
Don't worry about
Any
being done before.
any further discussion? I do
On
have
the-
one
on the
one
mailer.
question on this, and it has to do more with, I guess, campaigning this at the end of this. Once it's turned in and ready for, the county has it and we're waiting for this election. Do we need to have some sort of a campaign plan, or does the city want this board of freeholders to?
The city
Promote
will
it.
have, the city will have nothing to do with campaigning for.
I understand that.
the thing. And so can't direct it, doesn't have an opinion on it about what you do to.
Are we allowed to campaign?
The city is not gonna have
This-
anything to do with it.
Yeah, the city can't do anything with it, but once you've approved it, once you've voted on it and it goes to publication, essentially the Board of Freeholders is done. And you can do what you want to do with going out and talking to people and pushing this. And even if you wanted to form a political action committee or something to put out ads or whatever it is, as long as it complies with the election laws, you're
Okay.
more than capable of doing that.
So
City won't have
back,
anything to do
any
with
any
that.
further discussion on that? Thank you.
We have a motion.
We have a
and
motion on the board, yeah.
No, but before we, if we go, we need to stay on the topic.
Yeah.
Yeah, we have a motion. Are we,
Is there a question on the motion on the,
any further questions on
I
that
don't think so.
motion?
Just a comment on the postcard itself. I don't know if that's something we're gonna, providing in English only or.
There will be English and Spanish.
Okay, thank you. So we have a motion out there to approve the postcard with the changes that Suzanne made. It was seconded. We've had some discussion. All those in favor? Opposed? Okay, thanks.
and then just after a vote, if you would, Chair, just acknowledge that the motion passes or the motion fails.
The
Just
motion passes.
I had a comment on what you said, Chairman. I think it would be good, once we're done and we all vote, we have the thing to the printers, that we just hold a meeting in a place where people could come, like we used to do at Litchfield Elementary School. Post it out there and say, this is the charter that is going to be going to for election. right?
We can do that, but we
And-
won't be
and-
freeholders anymore though, right?
Yes, we will. Yes, we're still freeholders until it's finally approved by the voters.
Well, I think as freeholders, your job as freeholders is done once you propose that charter to the, once it gets published.
So you're
Because
saying-
you have to vote on that. You have to vote to propose a charter. And once you vote and approve the charter to go to the election,
Right.
then I think that at that point, you are done as freeholders.
Can the city? No.
But we could
Let me finish. Can the
We-
city announce a meeting of the ex-freeholders that will take place at a location to come and answer any questions you have about what's being proposed?
I think what the best thing to do would be to put this on for an agenda item to discuss in detail at the
Okay.
next meeting as to
Okay.
how to handle things after.
Okay. So
The-
I'll talk to, we can talk about that when we make the agenda. We'll do that. Thank you.
Just because I don't want to go off too
Right.
far off topic, because right now we're just
Okay.
talking about
Okay.
the postcard and
So there's still one other item on the agenda. Is there any motion to table that item? The establishment of subcommittees, because we still haven't,
So moved.
okay. Is there a second that motion?
I'll second.
Any discussion?
And just so the board knows, a motion to table under Robert's rules brings it, the item comes back at the next regular meeting. So that if you table it now, then it'll come back and then you can table it.
Okay.
Just, so there's no question that it's still something that you can discuss in the
Correct.
future.
Yeah.
We're just not doing it at this meeting right now.
Correct. So all those in favor? Opposed? So the motion passes to table that item. If there's no further discussion, is there a motion to adjourn the meeting? Second? Any further discussion? All those in favor of adjournment? Opposed? Pass, we're adjourned. When I get my little deal.